Federal marshals arrived at Trump Tower this morning at 5:47 a.m. with court orders, not routine paperwork, active seizure warrants targeting $2.8 billion in assets belonging to Donald Trump. For the first time in American history, law enforcement officers are physically seizing property from a former president. This isn't theoretical anymore. Judge Patricia Morrison's 47-page ruling demolished every single emergency motion Trump's legal team filed, every delay tactic, every appeal for mercy, every claim of presidential immunity. Gone. According to sources familiar with the court proceedings, Morrison's language left no room for interpretation. The seizure begins immediately. Think about what that means. While most Americans were drinking their morning coffee, federal agents were walking through the marble lobby of Trump Tower with legal authority to claim everything inside: the penthouse, the commercial floors, the retail spaces generating millions in monthly revenue. All of it now belongs to the state of New York until Trump pays the $557 million judgment he's been fighting for 7 months. By 9 a.m., the first property transfer documents were being processed. Trump Organization employees watched as federal officials placed legal notices on executive office doors. Security footage shows executives hurriedly removing personal items, while marshals documented every piece of furniture, every piece of art, every asset that could contribute to satisfying the massive fraud judgment. And this is just the beginning. Sources speaking on background confirm that Mar-a-Lago property assessments are scheduled for next week. 14 golf courses across 7 states are already under federal lien. We're witnessing the systematic dismantling of an empire built on what a New York judge determined was systematic fraud. Here's the thing. Trump had 120 days to secure an appeal bond, 120 days to find someone willing to guarantee $557 million while he fought the fraud ruling. Nobody stepped forward, not Deutsche Bank, not any financial institution. When that deadline expired yesterday at midnight, automatic collection procedures kicked in. No more delays, no more negotiations. The law is doing exactly what it was designed to do. This morning, as federal marshals inventoried Trump's most prized possessions, we got our answer to a question that's been hanging over American democracy for years. Is anyone actually above the law? The officers walking through Trump Tower with seizure orders just provided the definitive response. They're not there for show. They're there to collect. To understand how we reach this moment, we need to go back to March when Judge Arthur Engoron delivered his devastating fraud ruling. $454 million in penalties. That was just the principal. With interest accumulating at 9% annually, that number has grown to $557 million as of yesterday. Every single day Trump delayed payment, he owed the state of New York an additional $135,000 in interest every day. Think about what that means financially. While Trump was filing motion after motion claiming presidential immunity, claiming the judgment was politically motivated, claiming he couldn't find anyone to underwrite an appeal bond, the debt was growing by nearly $1 million every week. According to court filings obtained by multiple news outlets, Trump's legal team submitted 6 separate emergency stay requests over 7 months. Every single one was denied. Here's where it gets truly significant. New York Attorney General Letitia James didn't just win a judgment and hope for payment. Her office spent 8 months conducting what sources familiar with the investigation describe as the most comprehensive asset inventory ever conducted against a former president. 127 properties identified across 12 states, bank accounts tracked through shell companies in 4 countries, real estate holdings documented down to individual parking spaces and storage units. We're not talking about a simple collection process. We're talking about a systematic mapping of an entire financial empire. James's team identified which assets could be seized immediately, which required federal coordination, and which involved international cooperation. They knew exactly where to send the marshals this morning because they'd been preparing for this moment since March. But here's what makes this unprecedented. Trump had options. Multiple legal experts confirm that securing an appeal bond, while expensive, was absolutely possible for someone claiming to be worth billions of dollars. Insurance companies routinely underwrite bonds of this size for major corporations facing large judgments. The catch was the due diligence. Any institution willing to guarantee $557 million would need to verify Trump's actual assets, his actual net worth, his actual liquidity. According to sources speaking on condition of anonymity, at least three major financial institutions began preliminary discussions about providing an appeal bond. All three backed out after reviewing Trump's financial documentation, not because they couldn't afford the risk, but because the risk assessment revealed discrepancies between Trump's public claims about his wealth and the reality of his financial position. The 120-day deadline wasn't arbitrary. New York state law specifically provides this window for defendants to secure appeal bonds in civil fraud cases. It's designed to be generous to ensure that even complex financial arrangements can be completed. Trump's lawyers requested two extensions of this deadline. Both were denied. Judge Morrison's ruling was explicit. The time for delays has ended. The time for excuses has ended. The time for compliance has arrived. When that deadline expired at 11:59 p.m. yesterday, automatic collection procedures kicked in immediately. This wasn't a decision made this morning. This was a legal mechanism that activated the moment Trump failed to meet his obligation. The marshals walking through Trump Tower aren't there because a judge woke up angry. They're there because the law is operating exactly as designed, precisely, methodically, without exception, and it gets worse for Trump's remaining legal strategy. His attorneys filed a final emergency appeal to the Supreme Court 3 hours after the seizure began. According to Supreme Court procedural experts, emergency petitions in civil cases have a success rate of less than 2%. The court typically intervenes only when constitutional questions of national significance are at stake. A real estate fraud case involving one individual, regardless of his former office, doesn't meet that threshold. We're witnessing the end of a 7-month legal strategy based entirely on delay. Every motion filed, every claim of immunity, every request for special treatment has been systematically rejected by every level of the judicial system. What began as a civil fraud case has become a demonstration of something much more fundamental. The rule of law applies universally. Today, federal marshals are proving that principle isn't theoretical, but federal marshals aren't seizing Trump's assets because of a simple debt collection. They're there because of a pattern. 7 months of systematic defiance that turned a civil fraud case into something much more serious. This isn't about money. This is about respect for judicial authority. The pattern started immediately after Judge Engoron's March ruling. Within hours, Trump posted on Truth Social attacking the judge personally, calling the decision a disgrace, claiming the entire New York judicial system was corrupted by political bias, not legal arguments, personal attacks on a sitting judge. That's contempt of court in any other case involving any other defendant. During the original civil trial, Trump violated court orders repeatedly. He spoke out of turn during proceedings. He made faces and gestures while witnesses testified. Judge Engoron issued formal warnings 5 separate times. When those warnings were ignored, he imposed a $10,000 fine for each violation. Trump paid the fines and continued the behavior. According to court observers, he treated judicial proceedings like a reality television show where he was the star. Here's where the defiance became systematic. Every financial disclosure order was met with partial compliance. When the court demanded complete bank records, Trump's attorneys provided summaries. When the court demanded property valuations, they provided estimates from Trump Organization employees rather than independent appraisers. When the court demanded complete asset lists, they provided categories instead of specifics. Think about what that pattern reveals. This wasn't someone cooperating with legal proceedings while maintaining his innocence. This was someone actively obstructing the court's ability to verify the truth. Each act of defiance was calculated to delay, to frustrate, to exhaust the judicial system's patience. It worked for months, but every system has limits. The breaking point came in August when Trump's legal team filed a motion claiming that seizing any of his assets would constitute cruel and unusual punishment because of his status as a former president. Not unconstitutional because of the amount, not unconstitutional because of the process, unconstitutional because of who he used to be. Judge Morrison's response was swift and brutal. She wrote that former presidents receive no special immunity from civil judgments, and that claiming otherwise demonstrates fundamental disrespect for constitutional equality. But Trump didn't stop. Even after Morrison's ruling, even after every appeal was denied, The attacks on judges and prosecutors intensified. Social media posts targeting court staff by name. Public rallies where he called prosecutors criminals and judges corrupt. Press conferences where he claimed the entire legal system was weaponized against him personally. According to legal ethics experts, Trump's behavior crossed every line of acceptable conduct for a defendant in civil proceedings. But because he was a former president, because his attacks generated political support rather than legal consequences, the courts extended extraordinary patience. That patience expired yesterday at midnight when the bond deadline passed without compliance. We're not witnessing random legal enforcement. We're witnessing the consequences of a calculated strategy that failed. Trump bet that his status, his political support, and his media manipulation could override judicial authority. He bet wrong. Federal marshals walking through Trump Tower this morning aren't there despite his defiance. They're there because of it. The system gave him every opportunity to comply, every extension he requested, every consideration his status might warrant, every benefit of every doubt. When someone systematically rejects every opportunity for compliance, when someone treats court orders as political talking points rather than legal obligations, the system responds the only way it can, with enforcement, with finality, with consequences that can't be appealed, negotiated, or tweeted away. The seizures beginning at Trump Tower this morning represent just the first phase of what sources describe as the most comprehensive asset recovery operation ever conducted against a former American official. We're not talking about symbolic enforcement. We're talking about the systematic dismantling of a business empire valued at over $2.8 billion. The timeline is precise and unforgiving. Trump Tower goes first because it's the most liquid asset, the easiest to transfer ownership and begin generating immediate revenue for the state. Next week, federal assessors arrive at Mar-a-Lago to conduct what's being called a forensic valuation. Every room, every piece of furniture, every artwork, every golf cart. According to sources familiar with the process, nothing will be overlooked because everything counts towards satisfying the judgment. But the Trump Organization's golf course empire presents the most complex challenge. 14 properties across 7 states are now under federal lien. Doral in Miami, Trump National in Los Angeles, Bedminster in New Jersey. Each property generates millions in annual revenue through membership fees, tournaments, and real estate development. Each property employs hundreds of workers who showed up to work this morning not knowing if they'll have jobs next week. Here's where the human cost becomes devastating. The Trump Organization directly employs over 22,000 people worldwide: housekeepers, groundskeepers, security guards, administrative staff. According to employment law specialists, when assets are seized to satisfy judgments, existing employment contracts become the responsibility of whoever assumes control. That's the state of New York. Suddenly, New York taxpayers are potentially responsible for maintaining payroll at luxury golf courses they'll never be able to afford to visit. The bankruptcy implications cascade across the entire organization. Trump Organization CFO Alan Weisselberg, already serving time for tax fraud, managed financial relationships with over 400 vendors and contractors, construction companies that built Trump properties, catering services that handle events, landscape companies that maintain golf courses. All of them are now calling their lawyers, asking whether their contracts will be honored and their invoices will be paid. Think about what that means for Trump's 2024 presidential campaign. Campaign finance law requires candidates to disclose all assets and debts. How do you report assets that are being actively seized by federal marshals? How do you claim net worth when your primary revenue-generating properties are under government control? According to campaign finance experts, Trump now faces an impossible choice: report assets he no longer controls and violate disclosure laws, or report assets accurately and admit his campaign is financially crippled. International business relationships are collapsing in real time. Trump properties license his name to hotels, residential buildings, and golf courses in 12 countries. Sources speaking on background confirm that licensing partners in Dubai, Scotland, and Indonesia received legal notices this morning advising them that the Trump Organization may not be able to fulfill contractual obligations. Three major licensing deals worth an estimated $200 million in future revenue are now in legal jeopardy. Banking relationships that took decades to build are being severed within hours. Deutsche Bank, the only major institution willing to lend to Trump after his multiple bankruptcies in the 1990s, issued a statement this morning confirming that all outstanding loans are being called immediately. This isn't punishment. This is standard banking procedure when borrowers face asset seizures. When collateral disappears, loans become due instantly. Insurance companies are moving even faster. Lloyd's of London canceled policies covering Trump properties at 12:01 a.m., exactly 1 minute after the seizure deadline expired. Property insurance, liability insurance, directors and officers insurance for Trump Organization executives, all canceled. According to insurance industry sources, companies cannot legally provide coverage for assets under federal seizure because they no longer belong to the policyholder. The brand destruction extends far beyond property seizures. Trump branded merchandise, Trump steaks, Trump water, Trump University educational materials still being sold online. Everything carrying the Trump name now carries the legal baggage of fraud convictions and asset seizures. Marketing experts estimate that brand rehabilitation, if even possible, would require a decade and hundreds of millions in advertising investment. Here's what makes this systematic destruction particularly devastating. Trump built his entire political identity around being a successful businessman, the man who wrote The Art of the Deal, the billionaire who could bring business expertise to government. Federal marshals walking through his properties with seizure orders aren't just collecting debt. They're dismantling the foundational myth that launched his political career. Real estate agents in Manhattan report that Trump-branded properties are already seeing double-digit declines in value, not because the buildings are worth less, but because the name on the building has become toxic. Residents of Trump International are petitioning to change the building name. Owners of condos and Trump properties are hiring lawyers to explore breaking their association agreements. But perhaps the most personally devastating consequence involves Trump's children. Donald Trump Jr., Eric Trump, and Ivanka Trump all hold executive positions in the Trump Organization. All three built their professional identities around managing and expanding their father's business empire. Sources familiar with their legal situation confirm that they're now facing potential personal liability for business decisions made while the organization was under investigation. The seizures that began this morning represent more than debt collection. They represent the complete unraveling of everything Trump built over 5 decades. Every business relationship, every brand partnership, every licensing deal, every property that carried his name, all of it is being systematically dismantled by the same legal system he spent 7 months attacking. The empire isn't just shrinking. The empire is being methodically destroyed by the consequences of the decisions that built it. Legal experts across the political spectrum are calling this morning's asset seizures unprecedented in scope and constitutionally significant in their implications. According to former federal prosecutor Barbara McQuaid, no former president in American history has faced this level of civil enforcement action. Not Richard Nixon after Watergate, not Bill Clinton after impeachment, no one. Think about what that professional consensus means. McQuaid prosecuted public corruption cases for 12 years. She's seen governors, senators, and federal judges face asset forfeiture, but she's never seen anything approaching the systematic seizure of a former president's business empire. Her assessment is unambiguous. This is uncharted constitutional territory, and the legal system is handling it exactly as the founders intended. Asset recovery specialist Jennifer Rodriguez has supervised federal seizures worth over $2 billion during her 15-year career with the Justice Department. According to Rodriguez, the Trump Organization seizure represents the most complex asset recovery operation she's ever observed. Multiple jurisdictions, international licensing agreements, hundreds of interlocking corporate entities. She estimates that complete asset liquidation to satisfy the judgment could take 18 months. 18 months of federal oversight of everything Trump built. Constitutional law professor Lawrence Tribe confirms what legal observers have been saying privately for months. Presidential immunity, even for former presidents, applies only to criminal prosecutions related to official duties. Civil fraud cases involving private business conduct receive zero constitutional protection. Zero. According to Tribe, Trump's emergency appeals based on presidential status were legally frivolous from the moment they were filed. But here's where the timeline becomes crucial. Trump's voluntary compliance deadline expired at 11:59 p.m. yesterday. At 12:01 a.m., automatic enforcement mechanisms kicked in, but the seizure schedule doesn't end with Trump Tower. Sources familiar with the enforcement timeline confirm that federal assessors will arrive at Mar-a-Lago on December 23rd, 2 days before Christmas. That's not coincidental timing. That's strategic legal pressure designed to maximize compliance incentives. The December 23rd deadline isn't arbitrary. Florida property law requires 72-hour notice before residential property seizures, even in civil cases. That notice was served this morning. Mar-a-Lago generates over $50 million annually through membership fees, events, and licensing agreements. More importantly for Trump personally, it's been his primary residence since leaving the White House. Federal marshals will be inventorying his personal belongings, his private office, his living quarters, everything. Supreme Court procedural experts are unanimous about Trump's emergency petition filed this morning. According to Professor Steve Vladek, who studies Supreme Court emergency procedures, the petition has virtually zero chance of success. The court grants emergency stays in civil cases only when constitutional questions of national significance are at stake. A real estate fraud case, regardless of who's involved, doesn't meet that threshold. Historical precedent shows emergency civil stays succeed less than 2% of the time. Here's what makes the legal finality so devastating for Trump's remaining options. The Second Circuit Court of Appeals already reviewed this case twice. Both times, 3-judge panels unanimously upheld the lower court rulings. Both times, they found that Trump's claims of excessive penalties and procedural violations were without merit. According to appellate procedure experts, courts that have already ruled twice on the same issues virtually never reverse themselves on third review. But the countdown pressure extends beyond property seizures. Federal tax authorities are reviewing whether the Trump Organization maintained accurate tax filings while inflating asset values for loans and deflating them for tax purposes. According to tax law specialists, systematic asset misrepresentation can trigger criminal referrals to the Justice Department. We're not just talking about civil penalties anymore. We're talking about potential criminal exposure for tax fraud. International legal experts are watching these proceedings with extraordinary interest. According to Professor Ann Peters from the Max Planck Institute, the world is witnessing whether American democratic institutions can hold former leaders accountable for private misconduct. Authoritarian leaders from Hungary to Brazil are studying whether Trump receives special treatment or faces standard legal consequences. The global implications of American rule of law are being tested in real time. Banking industry analysts confirm that major financial institutions have been preparing for this moment since the original fraud ruling in March. According to sources at JP Morgan Chase and Bank of America, internal risk assessment teams have been gaming out scenarios involving Trump Organization asset seizures for months. The universal conclusion was that lending relationships with the organization would become impossible to maintain once federal seizures began. Insurance industry experts revealed that Lloyd's of London began cancellation procedures in November, weeks before the seizure deadline. According to insurance law specialists, companies cannot legally maintain coverage on assets under federal seizure because the policyholder no longer has insurable interest in the property. When ownership transfers to the state, private insurance automatically terminates. The professional consensus is overwhelming and unanimous. Every legal expert consulted, every procedural specialist interviewed, every constitutional scholar asked for comment. All of them confirmed the same conclusion. Trump's 7 months of legal challenges were destined to fail from the beginning. Presidential status provides no immunity from civil fraud judgments. Asset seizures are standard enforcement mechanisms. The system is operating exactly as designed. According to sources familiar with similar high-profile asset seizures, Federal marshals will complete their Trump Tower inventory within 48 hours. Property transfer to New York State control will be finalized by Friday. Revenue generated by Trump Tower commercial spaces will begin flowing to the state immediately. This isn't a symbolic victory for prosecutors. This is immediate financial satisfaction of a legal judgment that accumulated interest every day. Trump delayed compliance. Federal marshals seizing a former president's assets represents more than debt collection. It represents the answer to a question that has haunted American democracy since its founding. Can the legal system hold former leaders accountable for private misconduct, or do they exist in a permanent class above the law? This morning's seizures provide the definitive answer. No former president in 248 years of American history has faced asset forfeiture.